Thank you and good afternoon. As noted, my name is Reg Gakey. I'm a partner in Mayor Brown's Washington, D.C. office and a co-leader of the firm's commercial litigation practice. Joining me today as co-presenters are Sharon Israel, Trent Menning, and Lori Zahalka. Sharon Israel is a partner in our Houston office and a member of the firm's intellectual property practice. Trent is a senior associate in the Houston office and member of the firm's intellectual property practice as well. And Lori Zahalka is a partner in the Chicago office and member of the firm's employment and benefits practice. Before we begin, I have a few housekeeping announcements. First, as we go along, we hope that you all will ask questions by using the Q&A panel, which I'm told is on the right side of your screen as you're looking at it. We're going to make every effort to answer questions toward the end of the webinar. But if we're not able to answer your question during the presentation, we'll follow up with you directly once the webinar is ended. Second, regarding CLE credits, I know some folks may be looking forward to getting those here. We're going to be providing an alphanumeric code at some point during the presentation. In order to receive the CLE credits, participants need to record this code on the virtual sign-in sheet, which, as I understand, was emailed to all of you with the login instructions for today's program. And finally, the last preliminary comment, which is really a caveat. The views that are going to be expressed by myself, Sharon, Lori, and Trent are our own views and should not be attributed to the firm or to our clients. So with those preliminaries out of the way, let me give you an overview of our discussion today. Today, as the title of the seminar suggested, is the first of a series of presentations we're going to make on the Defend Trade Secrets Act and trade secrets generally. We want to today provide some bit of a background on the importance of trade secret protection and a discussion generally of the DTSA, including its key provisions. We're going to discuss the causes of actions under the DTSA and the new remedies that are available under the DTSA. And we'll also spend some time talking about the impacts on restrictive covenants and confidentiality agreements which impact employees and employee agreements. Finally, as we get towards the end of the agreement, we wanted the presentation, we want to talk about some of the steps that folks can take to ensure that there are tools in place for trade secret protection, and to talk about the considerations and advantages that companies should use in considering whether to use the DTSA to prosecute their trade secret misappropriation claims versus state law or some other IP remedy. So that's sort of an overview of what we're looking to cover today. Now, most people on this call likely already know the importance of trade secrets, or you wouldn't be on this call, but let me put some numbers on it. If you could turn the slide. There you go. It's estimated that trade secret theft, just trade secret theft in the United States, is worth anywhere between $250 and $300 billion annually. In fact, I've seen estimates that trade secrets are estimated to be valued at as much as $5 trillion in the U.S. economy. So these are obviously a substantial source of company value and company rights. Now, as most folks will know, the valuation of these trade secrets is obviously quite difficult, so those numbers are imprecise. In fact, we spend a lot of our time in litigation trying to put numbers on what trade secrets are worth. And this is typically because businesses often aren't aware that they have trade secrets that's even been stolen, or they're sometimes not able to identify what the specific trade secret is. But while trade secrets sometimes get less attention, for example, than patents or copyrights, the value to companies is massive, as these numbers show. And as a result, we've seen that trade secret litigation has been growing dramatically. If you could turn the slide. Data show that there's been an exponential increase in trade secret litigation in federal courts and a somewhat slower but more steady increase in state courts. And while the majority of cases are still being filed in state courts, an increasing number of cases are being filed in federal courts, largely brought as either pendent claims to patent litigation or on diversity grounds. In fact, the data shows that federal cases of trade secret theft doubled between 1988 to 1995. doubled again between 1995 and 2004, and are projected to double again by 2017. So the data shows that we already are seeing a substantial growth in federal actions with respect to trade secrets. And as you're going to hear, one of the impacts of the DTSA is, in fact, to make bringing trade secrets actions in federal court even more likely to be the case in the future as opposed to state courts. So the question is, who are these misappropriators who are likely to be the subjects of a trade secret claim by a company? If you turn to the next page, the data actually show that most trade secret misappropriators are somebody that the owner knows. In most cases, particularly in state courts, it tends to be employees who are the trade secret misappropriators. But the second category of misappropriators are business partners, someone with whom you've entered into an agreement to try to develop a product, or maybe a joint venture arrangement, or maybe you've just shared some secrets between two business partners. Those tend to be the majority of folks who are actually responsible for trade secret theft. The other two categories, being unrelated third parties and other unknown entities, tend to be actually much smaller. Now, the good news of that data for trade secret owners is that you actually have the ability to protect yourselves from a good bit of the trade secret thefts that occur in the form of employee agreements or non-disclosure agreements with business partners. In fact, the data shows that those two forms of precautions are often the most correlated with showing that businesses have taken adequate steps to protect their trade secret rights. So just taking those two steps will help trade secret owners protect their IP both before it's stolen and after it's stolen. Now, the trends that we've just talked about, the growth in value of trade secrets, the growth in the number of trade secret claims that are being brought, are some of the factors that have driven the adoption of the DTSA. If we can have the next slide. So when Barack Obama signed the statement for the Defend Trade Secrets Act, when he signed it in May, he noted that one of the biggest advantages to the U.S. economy is the fact that we innovate, and that those innovations often take the form of trade secrets. But he also noted, of course, that our competitors are often trying to steal those trade secrets from us, and therefore the view was that we needed additional protections. The view was that bringing those protections in federal court would provide companies with both more uniform law, because even with the Uniform Trade Secrets Act that's been adopted in 47 states, there have still been differences across states, and also with a better ability to enforce those remedies across borders through nationwide service of process and other things that come along with bringing cases in federal courts. But equally so, the drafters of the statute recognized that they did not want to step on the toes of the states. For example, there are state laws regarding employee non-disclosure agreements and the enforceability of those agreements, and of course there are state trade secret laws. And so the drafters of the statute made the statute not preemptive of state law. So there are both state law remedies and federal remedies that run in parallel, one to the next. So, of course, the passage of the DTSA has raised a number of issues in a number of areas. And as we've noted on the next slide, those areas include employment law. For example, there are specific disclosures that are listed in the DTSA that employers should consider, and we'll talk about those further during this presentation. The DTSA is also going to impact litigation. For example, owners have the ability to identify protections, identify trade secrets, and seek additional protections during litigation. There are other implications as well. There are implications on criminal law due to additional remedies under the DTSA. There are implications for intellectual property rights, including the increased uniformity in trade secret law, which might impact how companies think about what remedies to choose in protecting their IP. And of course, there are implications for cross-border enforcement of intellectual property rights. The scope of the enforcement of the DTSA is yet to be decided. And of course, when it comes to cybersecurity, the DTSA is going to be another remedy that companies should consider. So given the wide range of potential issues, we at Mayor Brown thought it would be helpful to put together a series of seminars and webinars across all of those topics. And so that's what we're going to be putting together, and this is really the first of that series. This session is really intended to provide a background on the DTSA itself and highlight some of the issues, particularly in the employment law context. And so with that, let me turn it over to Trent to give some additional background on the DTSA.
Thanks very much, Reg. So I'm going to be starting with just an overview of the DTSA generally, some of its key provisions. And so some of you are probably already aware of the pre-existing federal law that addressed trade secret misappropriation, and that was the Economic Espionage Act of 1996. But really that only addressed criminal penalties. And so what the DTSA did was it amended the Economic Espionage Act to add, for the first time ever, a federal civil cause of action for trade secret misappropriation. And as Reg mentioned, this was enacted May 11th, 2016, and it covers acts of misappropriation that occurred on or after that enactment date. As something that won't be very surprising for a federal law, the trade secret needs to be related to a product used in or intended to be used in interstate or foreign commerce in order for the DTSA to apply. Some of the overview of the provisions under the DTSA, the remedies for the most part will be somewhat familiar. Damages and injunctive relief are available. One thing that's interesting that we'll discuss in a little bit more detail later is the ex parte civil seizure remedy that's available under the DTSA. It also has provisions for securing and protecting trade secrets during litigation. For example, once there's been a civil seizure, the court is required to take custody of the seized property and has to secure it from physical and electronic access until there's been a hearing on the matter. And that means that if, for example, information is stored on some sort of storage medium, it can't be connected to a network or the internet until there's been a hearing. There's also increased criminal liability under the Economic Espionage Act of 1996. The limit was no more than $5 million, and that's been changed now to be the greater of $5 million or 3 times the value of the stolen trade secret to the offending organization. And that would include any R&D costs or other costs that the offending organization or person, I guess, has avoided by misappropriating the trade secret. So depending on what type of information is at issue, you can see how that could pretty quickly exceed $5 million. So that's a pretty significant criminal penalty that can be in place now. There's also provisions for immunity for certain disclosures, and that has an impact on non-disclosure agreements, and that will be discussed a little bit later as well. So for those of you who have dealt with trade secrets in the past, you're probably very familiar with the Uniform Trade Secrets Act, the UTSA. So we thought it would be helpful here to provide at least a very high-level overview of the comparison between the DTSA and UTSA. And you'll find that for the most part what we're going to address here is very similar to what is in the UTSA. So, for example, the definition of a trade secret is similar to the definition that was in the UTSA, and this was already in the existing statute before the DTSA was implemented. And I won't go through this entire thing, but you'll recognize that it's a very broad term, what can be a trade secret. All forms and types of financial, business, scientific, technical, economic, or engineering information, that's obviously very broad. And it doesn't really matter what kind of form it's in. It can be tangible or intangible. It doesn't matter how it's stored or compiled or memorialized. It can be physical, electronic. As long as the owner has taken, and this would be important, reasonable measures to keep such information secret, and the information derives independent economic value, either actual or potential, from not being generally known to and not being readily ascertainable through proper means by another person who can obtain economic value from the disclosure or use of the information. So continuing on with the comparison of the DTSA versus UTSA, the acts of misappropriation of trade secret are also similar to those that are in the UTSA. In general, the acquisition of a trade secret by a person who knows or has reason to know that the trade secret was acquired by improper means. And improper means includes theft, bribery, misrepresentation, breach or inducement of breach of a duty to maintain secrecy, or espionage through electronic or other means. And improper means does not include things like reverse engineering, independent derivation, or any other lawful means of acquisition. Other acts of misappropriation of trade secret, disclosure or use of the trade secret without express or implied consent by a person who used improper means to acquire knowledge of the trade secret, or knew or had reason to know that the knowledge of the trade secret was derived from a person who used improper means to acquire the trade secret, acquired under circumstances giving rise to a duty to maintain secrecy or limit use of the trade secret, or derived from a person who owed a duty to maintain secrecy or limit use of the trade secret. And also disclosure or use of the trade secret, again, without express or implied consent, by a person who, before a material change in the position of that person, knew or had reason to know that the trade secret was in fact a trade secret, and knowledge of the trade secret, sorry about that, had been acquired by accident or mistake. So taking a look at the remedies, again, the remedies are somewhat similar up to a degree. What's listed here are the remedies available under the DTSA. So there's injunctive relief available, damages, including actual loss, unjust enrichment, or reasonable royalty, and exemplary damages for willful and malicious misappropriation. And that exemplary damage amount can be up to 2 times the amount of compensatory damages. Also available are reasonable attorney's fees to the prevailing party under certain circumstances, and under the DTSA, those circumstances would be a claim of misappropriation made in bad faith, motion to terminate an injunction is made or opposed in bad faith, or the trade secret is willfully and maliciously misappropriated. And one thing that the DTSA adds is the civil remedy we mentioned before, or the civil seizure remedy, which we mentioned previously. I'll talk about in just a little bit of detail here. There's obviously a lot more about the civil seizure remedy that we can discuss, and that's something that we'll be addressing in one of our future presentations in the series. But we wanted to give you an overview of it here because it is interesting. So the court can order ex parte seizure of property that's necessary to prevent propagation or dissemination of the trade secret. And it needs to be based on an affidavit or verified complaint. And one thing you'll know if you've looked through the DTSA, and something that we'll go over in a later presentation, is the requirements for issuing the order are very strict. But for example, a TRO or a preliminary injunction or other equitable relief have to be inadequate because the misappropriator would avoid or not comply with the order in order for the court to issue an ex parte seizure order. There needs to be an immediate and irreparable injury if the seizure order were not to issue, and there's going to be a balance of harm, and that also includes balancing the harm to the legitimate business interests of the misappropriator. So that will be a consideration that comes into play when considering whether or not this will issue. The moral of the story here is that this needs to be narrow. It needs to be the narrowest seizure that's necessary to prevent the propagation or dissemination of the trade secret. So we're really trying to get it to just what's essential to prevent this from happening. The order needs to direct for the seizure to be conducted in a manner that minimizes interruption to the business of not only third parties, but also, to the extent possible, the legitimate business interests of the offending party. And the order needs to be accompanied by an order that protects the seized property from disclosure. So until the hearing, there needs to be an order that accompanies this that will prohibit access to the information by the applicant and the offending party, and it prohibits copies of the seized property from being made. And with that, I will turn this over to Lori to begin with injunctive relief.
Thanks, Trent. So as Trent mentioned, injunctive relief is an available remedy under the statute. However, there are a few caveats as to what kind of injunctive relief is available, and those caveats are primarily related to what can be enjoined in the employment context. So there's basically 3 limits on injunctive relief set forth in the statute. The first is that injunctive relief cannot prevent a person from entering into an employment relationship. The second one is that the injunction cannot place conditions on employment that are based only on information the person knows. So this is otherwise known as the inevitable disclosure doctrine that some jurisdictions subscribe to, but that is not a basis for an injunction under the DTSA. Rather, plaintiffs seeking to get an injunction have to show actual evidence of threatened misappropriation. And the final limit on injunctive relief is that it cannot otherwise conflict with the state law that prohibits restraints on the practice of a lawful profession, trade, or business. So some state laws broadly reject restraints on employment. California is the major one that comes to mind that prohibits a contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind. So to the extent that an injunction would conflict with applicable state law, that injunction cannot issue under the DTSA. But it's important to keep in mind, I think, that whatever remedies are available under applicable state law as far as injunctive relief is concerned would still be available assuming that a plaintiff asserted the appropriate claim. So the limits on injunctive relief are just related to claims under the DTSA. You know, oftentimes we see in employment cases there are non-competes and non-solicit agreements that are used as a basis for injunctive relief, and a plaintiff wouldn't necessarily have to rely on the DTSA. Moving to the next slide, we'll talk about another employment-related issue under the DTSA, and that's immunity for certain whistleblowing activity. So the statute provides immunity from liability under any federal or state trade secret law if trade secrets are disclosed under certain limited circumstances. And there's really 3 sort of ways in which an individual can get immunity for disclosing trade secret under the DTSA. And the first is if the disclosure is made in confidence to a government official or to an attorney solely for the purpose of reporting or investigating a suspected violation of law. The second circumstance in which immunity can be granted under federal or state trade secret law is if the disclosure is made in a complaint or other document that's filed in a lawsuit or other legal proceeding, presumably before a government agency, although this particular provision has yet to be litigated. So we'll see how that plays out. But as long as the filing is made under seal to protect to the extent possible the confidentiality of the trade secret. And the third circumstance in which immunity is granted is if the individual is bringing a lawsuit for retaliatory activity against the individual for whistleblowing activity that the individual has undertaken. There will be immunity as long as any document containing the trade secret is filed under seal, and disclosure of the trade secret can only be done pursuant to court order. Moving to the next slide, related to the immunity provisions, Trent, if you can just move to the next. Oh, sorry, I see you've already done that. Okay. In order to, so there has to be notice of this immunity that I just talked about in certain employment agreements. And it's a contract or agreement with an employee that governs the use of a trade secret or other confidential information. And it's important to note that the DTSA broadly defines employee in this context to include consultants and independent contractors. So a company's notice obligation is going to extend to agreements with these particular individuals. It's not just traditional employees that these notification provisions apply to. Alternatively, the statute allows, instead of providing notice in agreements, the agreement can cross-reference a policy document provided to the employee that sets forth the employer's reporting policy for a suspected violation of law. So this has left many companies with the question of, okay, well, what exactly do we put in our employment agreements and our confidentiality agreements that fall within these notification requirements? And at this point, the only answer we have is that the statutory language is the only thing that seems to be a bulletproof way to comply with the notification provision. There hasn't been any litigation as to what other sorts of language might satisfy the notification requirements. But you can use the alternative, which is to cross-reference the policy document. And the statute is not clear as to whether or not any cross-reference policy document would have to include this language, the immunity language from the DTSA itself, although you know, it would stand to reason from the most conservative perspective that if you're supposed to include the language in the agreement, the alternative to cross-reference the policy would mean that, of course, you have to include the language in the policy. But again, this has not played out at all in the courts, so we'll have to see how things progress once the courts start addressing these issues. Keep in mind that the notice provision applies to any new or updated agreements. So any agreements entered into post-May 11th, 2016 need to have these notification provisions of the whistleblower protection in them. You don't need to go back and amend previously existing agreements. And just keep in mind that there are a host of agreements that companies enter into with their employees. It's not just necessarily NDAs or non-solicit, non-compete confidentiality agreements. You might have confidentiality language in a bring your own device policy, computer use agreements, severance agreements, and it's likely to be that notification provisions have to be in each and every one of those agreements. And I think we can safely assume that eventually there will be employees who have a host of agreements at issue, most of which contain the notification provisions, but if one confidentiality agreement doesn't have the notice language in there, you may not be able to recover against the employee in any litigation under the DTSA, exemplary damages, or attorney's fees. Those are the consequences for not including the notification language in the applicable agreements. So with that, I think I will turn it over to Sharon, who will talk about steps to protect your trade secrets.
Thanks, Lori. So most of the steps that I'm going to talk about aren't really new in terms of trade secret protection, or the DTSA generally, or the DTSA in particular, I should say, with the exception of what Lori was just talking about, you know, as discussed with respect to evaluating agreements and policy manuals to update those to include, or to update with respect to any new engagements and new agreements to include appropriate notification with respect to the immunity provision. However, the DTSA does give, from an intellectual property standpoint, IP owners, developers more flexibility and opportunity as to whether to protect things, protect inventions, protect information through trade secret or patent or other means. And that we'll address that topic in more detail in an upcoming webinar. In general, trade secret owners should engage in reasonable efforts, take reasonable measures under the circumstances to protect their trade secrets. Controlled disclosure to employees or licensees that's consistent with the requirement of relative secrecy is, in general, reasonable, and that comes directly from the comments to the Uniform Trade Secrets Act. Some considerations or steps to take in terms of determining whether a company person is taking adequate measures, reasonable measures, could start with just identifying trade secrets and processes and determining what's in place for designating such information, for identifying and designating such information as confidential. One way to do that would include just reaching out to different groups within a company, from research and development to design to sales, to determine what kind of information is out there, what processes do they have in place for identifying and designating confidential information. Another good practice is to identify procedures that are in place for maintaining trade secrets and confidential information. And that can start with procedures for obtaining a title to trade secrets. For example, it's good practice to have agreements that make it very clear as to who owns intellectual property through assignments. This doesn't just apply to employees, but it would apply to third-party agreements with third parties, contractors. So identify what types of procedures are in place. In addition, what designations are used to mark trade secret information as confidential? Do you have those kinds of procedures in place? Are there different levels of confidential information? Is it clear that such information is appropriately identified and marked? Review confidentiality agreements that you may have with employees, with consultants, with third parties, and policies and procedures manuals as well. Now, this is really talking more on the just identifying what you have in terms of trade secret information within a company, or that a person has in order to try to maintain its trade secret status. One thing on the employee side, on the inbound side, is be careful about managing inbound risks. When bringing on an employee, a contractor, getting into an agreement with a third party, take measures to prohibit the use of confidential information that's obtained from a prior employer. Make it very clear that that kind of information should not be used, and that can be clear in any kind of agreements, offer letters, or the like. Next slide. So turning to the next slide, on one good practice too is to identify how trade secrets are maintained and make sure that the proper measures are in place. For example, identify how is access limited, and it should be limited just to persons with a need to know. And that may differ from one type of confidential information to another. Determine how the trade secret or confidential information, how access is physically and electronically handled, and make sure that it is as secure as it can be, that you've taken reasonable measures. Check security measures for accessing trade secret information. That could be anything from, there's some courts that have determined that just having something password protected may not be enough. You probably need to have have information that's encrypted or otherwise stored. And in general, though, verify that there's measures in place to limit access just to those who have a need to know, and that those measures are sufficient and appropriate based on the type of information it is. Determine the company's policies or practices for educating employees and consultants on confidentiality requirements and practices. Basically, what you want to do is create an environment and ensure you have a continued environment where there's where confidentiality is something that is expected. While there may be circumstances where you would be able to rely on just an implied obligation of confidentiality, don't rely on that as being sufficient should you need to and want to enforce rights going forward. So it's best to do, take the reasonable measures to make sure that you've got an environment of confidentiality where that is the norm, what everybody expects. One area that is particularly ripe for trade secret misappropriation issues to arise deals with departing employees. And it's important to review procedures on how you deal with departing employees, including doing things like disabling access to company systems, accounts, equipment that an employee may have. Give them a reminder give them a copy of any agreements that they've signed, of the company's policies with respect to confidentiality. So remind them, and probably have affirmations really throughout, maybe annually, with respect to an employee's obligations of confidentiality. It's good practice to provide written acknowledgments on departure, so that you can go through basically a checklist of all the items that for a departing employee to make sure that you've got a good record of what it is that they were appropriately apprised of their obligations, that they had knowledge of their obligations on departure. One area that's getting, I think, more and more important and probably just difficult can be difficult to manage are some of the electronic security measures in particular. But it's important to review not just the physical measures that are taken with respect to protecting trade secret information, but the electronic security measures that are in place.
Sherry, I'm the conference operator for today's call.
As well as
and then it looks like you're going to be the one on chat today. You should see my hello.
We have some bleed over from another call. Great. Sorry if there was some additional noise on the line. Anyway, one of the things that is to continue on, it's important to go ahead and review security measures, physical, electronic, in addition to the policies of the company, to make sure that there's appropriate steps and measures that are in place to protect trade secret confidential information. Remember, it's not just the internal policies and procedures, but also procedures that may govern any external access by persons outside the company for trade secret information. If you're using things like Dropbox and public third-party hosted sites, those may or may not be sufficient for handling trade secret information.
Yeah, Sharon, if I can just jump in for a second, because I think one of the questions that was asked is whether computer hacking has had an impact on what's reasonable, and I was just going to note that in this context, we've certainly had a case where it's not the hacking so much. It's not like, you know, if somebody hacks you, they can argue that, well, your protections weren't reasonable because I was able to access it. But it is, as you mentioned, Sharon, the emails and things like that. We've certainly argued in cases where, you know, somebody has taken certain materials and then sent them off to somebody else via email that, you know, even though they had non-disclosure and whatnot, that by sending it via email, it was, you know, suggesting a lack of protection because emails can be forwarded along, et cetera, and there was no other way to protect it. So I don't know if you have any other experiences there, but, you know, it's certainly an experience I've seen.
Yeah, I think in general that it probably has elevated to some extent the requirements for what's reasonable, and we will be having a separate webinar focusing on the cybersecurity measures. Cyber attacks has become a very big issue, and I think it's only going to become a bigger issue. So while, you know, the departing employee has been probably one of the biggest sources of trade secret misappropriation issues, the issues with respect to cyber attacks may be the next generation that is going to be going to make it all the more important to take reasonable measures and to probably take what's heightened measures with respect to cybersecurity. One issue that I won't get into, but just will mention briefly too, is just beware of social media and what employees are doing with on the social media side. In general, be prepared to take prompt action. One thing with respect to enforcement of trade secrets is you just need to be prepared to enforce your rights and enforce your rights promptly. And that one of the first measures will be just having a litigation hold, but be prepared to go to the next step, to whether it's through the DTSA or state court or otherwise. But it's going to be important to show that you are taking the reasonable measures on the enforcement side as well. Next slide. So I think we'll all add in some commentary here. One big advantage, as Reg started out talking about with the DTSA, is it is a new tool. It adds predictability and breadth. It gives access to protect trade secrets in federal court. That wasn't, the access to federal court was not always as certain when you're relying on the state law under the UTSA or common law. In federal court, we have known rules and procedures, the broad subpoena power. We should have more predictable results, although we don't have a lot of case law yet, and so we're going to have to see how that develops. And hopefully we'll have fewer jurisdictional problems, and potentially it gives you the opportunity to avoid undesirable state jurisdictions. But it's also important to note that the DTSA doesn't preempt other laws. So it gives exclusive jurisdiction, or it gives original jurisdiction, not exclusive jurisdiction, so it's adding a level of protection instead of replacing existing state laws. And
oh, sorry,
go ahead, Reg.
I was going to say one other thing with respect to the federal courts. So in a lot of state courts under the UTSA or separate state statutes, they will require a trade secret claimant to identify what the specific trade secret is and really spell it out. Here are the 5 trade secrets I believe you've taken. There's nothing parallel to that under the DTSA, and it's not clear whether it will be implied by the federal courts. From an accused infringer's perspective or misappropriator's perspective, that's a very important protection that state law provides, and it will be interesting to see whether or not federal law goes in that direction. From a trade secret holder, that would be a benefit, I think, of proceeding through federal court. Right,
and there still may be advantages to bringing suit in state court. A lot of times from a plaintiff's perspective, state court can be faster. There may be advantages with respect to the level of identification that you need to make of a trade secret up front. In federal court, you need to have a unanimous jury. That's not necessarily required in state courts. There is no inevitable disclosure doctrine under the DTSA, and at least some states do recognize inevitable disclosure. Does anyone else want to add in other advantages or other considerations? One issue we were talking about before we got started was with respect to sort of negative information being protectable. There is a in-commerce clause requirement, as Trent mentioned, with respect to the DTSA, and while that doesn't seem to generally be a difficult hurdle to meet, it could be with respect to kind of negative trade secret information that might be something that may or may not be met. But I think we'll have to look and see how the law develops in that area. So one issue that, as Lori touched on, one of the first issues you should even want to look at will be employment agreements and policy manuals and what may need to be updated. As she said, there's nothing formulaic yet that we know as to what's appropriate language other than the statutory language, and so we'll have to see how things develop in terms of what shorthand notations may be appropriate, and but one thing to consider right away is to what extent should agreements be, should at least agreement templates be updated, policy manuals be updated, and but also to note that you don't need to update existing agreements as they're currently in place. There is no body yet of federal law under the DTSA, except to the extent that you have such law under the Economic Espionage Act. So we will likely experience some growing pains as the courts struggle both with state and federal laws.
Yeah, I can weigh in there. I know we've looked at a couple of cases. Obviously, this is a new statute and has not been interpreted by many courts. The courts who have looked at it have typically concluded that the DTSA results would not be that different from state laws, but those are mostly at a motion to dismiss or sort of procedural level, so nothing that you can really take to the bank yet. At least one court has suggested that the definition of trade secrets is broader under the DTSA than at least the applicable state law, but it's not clear to me that broadening is something that would be materially important. So I agree, though, that there's going to be a lot of interpretation of this statute and a lot of stress and pressure put on the statute and an attempt, I think, to incorporate the UTSA precedent into some of the DTSA case law.
So going back on the notice requirement, one question we received was, does the notice apply to LLC members that receive guaranteed payments? Lori, did you have any thoughts on that?
Sure. I mean, the statute uses the word employee, and it defines employee as any individual performing, it includes any individual performing work as a contractor or consultant for an employer. So I think typically members of LLCs are generally not considered employees of the LLC, but I think, and of course we haven't seen any litigation over this yet, but it's important to perhaps look at the duties and responsibilities of the particular member, and if the member is functioning as an employee would in terms of providing services and day-to-day management and other sorts of sort of traditional employee work, you might consider in any updated or revised amended agreement entered into going forward with the member that would fall under the DTSA to include the notification language. You know, that's sort of the way that I would think about it, because the statute, the way that it defines employees, seems to contemplate, well, not necessarily traditional employees, but anybody who's performing work for the company. I don't know if anybody else has any other additional thoughts on that. That's the way that I would approach it.
Just one last point I wanted to make was just some of the advantages of the DTSA includes its extraterritorial reach, which is much broader than the existing state laws. And we will be having a subsequent webinar dealing with some cross-border issues and strategic considerations. One thing to keep an eye out for is the EU directive for trade secrets and its implementation in EU countries over the next couple of years as well. It's very similar to the DTSA in many respects. Does anyone else have any comments or questions?
I see we've got a question as to how the DTSA impacts non-competes, or is life still the same? I'll defer to Lori on that one. My reading of the statute is that, at least to the extent that state laws limit your ability to have non-competes that prevent employment, that this was not supposed to preempt them, but I'll defer to Lori on that question.
No, I think that's right, Reg. I think by and large, life is still going to be the same as far as non-competes are concerned, although certainly pay attention to any language in a non-compete that has confidentiality restrictions in it, and to determine whether or not the notice language needs to be in there. But in terms of litigating non-competes, I suspect that the analysis is not going to be changed much by the DTSA, and indeed there have been a couple of federal cases so far under the DTSA alleging trade secret misappropriation, but employees leaving one company and going to another, and non-competes were involved in both. And one was in the Eastern District of California, where the non-compete was not enforced and the injunction did not issue because the non-compete was unenforceable. And the other case was in the Eastern District of Missouri, and the non-compete was found likely to be enforceable, and it prevented the employee at issue from entering into a new employment relationship. And the DTSA didn't appear to have any sort of effect on the court's analysis in those two cases. So I think we're still operating in the same world by and large, outside of the notification requirements.
All right. So I think we answered the questions that we received, but if anyone has any additional questions related to today's topic, please email them to Annie Leger at ALEGER@mayorbrown.com, and your questions will be promptly forwarded to the panelists. And we thank you for your participation today and hope you have a great day.